a heightster now, or you still like?
All right, Yaya, who is it?
Page 2, 421.
2003 building.
Catherine Flores.
Y'all have a kids up?
Hello, how's it going?
It's been a transition.
Yeah, I can imagine.
It's good though.
All right, so today is the plea deadline date.
We don't have an agreement.
All right.
I do.
No, we did the blood.
Oh, you've
I
changed?
chose on something.
Oh, okay.
What will it, what do we have to talk about?
Yes,
first?
let's talk.
Okay.
Yes.
Okay. I'm sorry.
No.
Sorry.
Oh, they look kind of.
All right, who's next?
1, 2, 14. First one
All
down.
right, and state on Catherine Flores, they say that they have an agreement, maybe. That's on page 2, 4 down.
Okay. No, it's the same. It's around and then I'll put that on.
All right, so this is going to be back tomorrow.
Always weird to let other.
And Norma, that'll be tomorrow. Well, actually, Norma, Lauren is going to see whether or not her witnesses can hang around. The state is saying they only have about 2 more witnesses.
So, Judge, I was just talking with Ms. Leonard about it. She was saying that she would object to Zoom. And one of my officers has to pick up his son at 4. So I explained to him, I don't really know how soon or late, so I don't know what.
Okay. So, can you have them come in? Please.
Wherever my food is, it's like, I guess when the cops come, turn around, always come around. Oh. Other guys still package on the door. That's what they came in yesterday, so. Oh, there's a bunch of children down.
She was just being polite, but was letting the rest of us.
And-
You think like this cheap jewelry. I'm like, oh my God. I looked up people in this guy's messing with my package, so I think this is somebody dropping it off. Right. So I had my kid with me on the ground, like, hey, what's going on? Sell my package? Oh, I don't know, I'm here to sell windows.
Hello.
Hey.
Hi. Hello.
I shut the door.
All right.
Watch.
So, as you all know, in this court, docket starts at 9 a.m.
Start
I'm always here at 9 a.m.
park down the street.
Sometimes all parties are not here exactly at 9 a.m. And so I announced to everyone that our jury trial will be starting at 10:30. So of course I had to stop and start the jury trial. What I've done is I expect this trial to be concluded today. So I can have you all come back tomorrow and we will start with you all at 1:30. Exactly. I will be here at 1:30. Defense attorney will be here at 1:30 and the state will be here at 1:30. Do y'all have any questions about anything? All right. Thank you so much for understanding and I appreciate your patience. Thank you.
You guys be careful.
May the defendant and I then be excused.
You need to get a reset for Ms. Ferguson.
Yeah, that's it. See you later, maybe. Bye, guys.
Said Catherine Flores, right, Judge?
Yes, her attorney is speaking with her outside. Oh, here she is.
The offer.
Judge, in the category of it's a small world, the 3 officers that were in here, if they're
Mm-hmm.
on bike patrol. I'm trying to get the bike patrol downtown substation to move into my building. So
Mhm.
I know these guys really want, he goes, are you the defense attorney? I don't want to be the defense, I don't want you to be the, no, it's a different case, different case.
So Norma Guzman Juliana on page 1, that's coming back. What date? All right. And then Philip Perez, did you get an update on the competency eval?
No, she has not responded back to the internet drive.
And then Norma. On Cantu, is that gonna be 12:15 as well?
Yes.
All right. And then Dollar
The 15th.
and Flores, they have an agreement, so that should be worked out. And then Pomeratz, 12:15.
Yes, ma'am.
And we need to take up Jonathan Rodriguez. If you can call Alfonso Cabanas.
Actually, he's in Dallas.
All right. And then Nicholas Vaquera.
No, Judge. Mr. Hagee is here.
What is happening with that case?
believe the prosecutors in trial sent them 6 pieces of mitigating evidence.
All right, so this is,
Trying to work out a deal.
all right, Ms. Ferguson?
Yes, sir.
And who is the prosecutor who's handling this?
Rick.
All right, Norma, on this case,
Yes, sir.
recall it for Thursday. Yes. And there'll be no further extension of the plea deadline date after that date.
$9 a.m. setting, Your Honor.
Yes,
Thank you.
you're welcome. And Jonathan Rodriguez on page 4. Can you check to see if there was a handwritten reset for him? Thank you.
I do both.
Your level again. I'm trying to get some of that, you know. Yes. I know.
And Norma, on page 5, De La Garza is the 15th as well.
Yeah.
All right. So all of the jail cases are the 15th, correct?
Yes, ma'am.
All right. I just want to make sure, that's why I'm asking. And make sure that nothing had changed. Who's here on Luis Medina? He's on page 7.
Oh, Eric Hernandez, he said he was gonna come in, Judge. I don't know if he ever made it in. Mr. Medina. Eric got a visit and told me he had work facility. And he said he would be here.
Zana made it this year. So, you know, for me,
All right, and State, I believe Ed Garza told you what the issue was with Carlos Gonzalez.
He's asking for us to keep all this stuff. They put it at red and all on.
When do you want it recalled for?
So
All right, and,
I'll be back with the year, exactly after the meeting.
okay. Do you want to do it the week of the January 5th?
That's fine, dude.
All right, Ms. Ferguson, can you put for disposition on page 7, Carlos Gonzalez, the week of January 5th?
Yes.
All right, thank you. What date?
Oh, you did. January fifth,
The week of January 5th.
January fifth.
January first is fine.
All right, once your client signs the reset form, you'll be excused.
Thank you.
Francisco Alvarado? He was here this morning.
Yes, ma'am. That case for reset to December 18th.
Gabriel Pizana? What is happening with this case?
Judge Oliver, I will take your.
All right, thank you. And Norma, on Pizana, set it for a plea deadline date for the last week in December, that week of the 15th. What date? All right. You say December 15th?
Yes, sir.
Okay. And if you'll give them a reset form.
Then when it's trial time. Oh, red flag up there, and I go, 3 in a row, one ended, the next day, another person. Oh, last time, we're good, but, well, you just make me get married here. No, I'm not, you know. I'm talking, which thing is supposed to. Then I got a picture of the ladies. Luckily,
Good, happy holidays.
Oh, happy holidays. You have a great one. I always tell everybody, Happy New Year, Merry Christmas, Happy Festivus, Happy Kwanzaa, Happy Holidays, and everything in between. Happy Hanukkah.
That too, sure.
Yeah.
I tell my wife that she's Mexican Jewish because of the way she penny pinches everything. So anyway,
All
no
righty.
pun intended. I'm sorry. I
Oh,
should be making a little bit. Thank you, sir.
you're welcome.
I don't know if you remember that really happened. Yeah, exactly. Please. Sure.
And have y'all worked out the issues with officers?
All of the officers are here.
Okay,
Let's just, whatever they want to call
all right, thank you.
My part is done, Judge.
Okay,
All witnesses were here, I'm done.
all right.
This is me kicking the can to sit. Throw them under the bus. Even though, look, I think you.
It's not too hard.
Yes.
Are you gonna handle some document before we start the file up again?
They're just doing a plea, so there's only one thing left to take care of. Yes. Oh, no problem.
Judge and the MCR docket.
Mhm.
David Loretto. Defense is asking they can come to this.
I'm sorry, who?
Loretto. can you come? Okay, scroll the top.
You say page 12?
Yeah, each 12. David,
Yes.
Yeah. this is perfect.
Okay. All right. Bashan
Judge,
Romero on page 12. That's gonna be on Thursday. Mhm.
At the office, he comes in. Ever.
Yeah, you're touching that. You're touching that. Increase negative number is close. Jail mill.
This dictionary words.
Yeah. I mean, in the hallway, yeah.
Oh, Bashan. All right, everyone, please be seated. And you're still under oath and state, I believe it's your cross, is that correct?
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. Ms. Evans, just to refresh where we left off, we were at the point questioning where Duran had reached back and pointed halfway, I guess you could say, to Zanani, right?
Right.
Your knowledge, did Zanani have to lean forward when she slapped his hand like you testified to?
I don't recall, but I don't recall her being leaned forward.
All right. After this incident occurred and I guess let's say Duran and Zanani were outside of the vehicle. Did you ever have to get out of the vehicle to check your daughter?
No,
Did you ever check her neck?
no,
Did you ever see Duran again, after he left?
did I see him again after?
That's, that's his question. I mean, like they're in the area after he got out and walked out.
No,
Okay, I'm assuming you saw him later on at home at some point, right?
correct.
Okay, thank you. So what you testified to earlier about Zanani and all her issues, is Zanani considered like the black sheep of the family?
I wouldn't think so. I think that everybody has been trying to be patient and help her. But you have to be able to receive that. You have to want to be helped. So I don't think that he's that.
At any point while all occupants of the car were inside of the car, did Duran ever turn around?
Did he ever turn around, meaning his whole body turn around, or no? So I guess if I'm answering that question, if this is a turnaround, then this is what he did.
I guess that's probably confusing. Did he ever turn around and face Zanani?
No,
Okay. Have a moment, Sean?
Yes.
Your Honor, at this time I'll pass the witness.
I have no questions, Your Honor.
All right, is this witness excused or subject for recall?
Please by the state.
She's excused by the defense, Your Honor.
All right, the rule has been invoked. What that means is you're not allowed to discuss your testimony with anyone or view anything about this trial until this trial has been concluded. Do you understand?
yes, ma'am.
All right, if you'll remove that tiny microphone. Thank you. Defense, call your next witness.
Defense would call Officer Kyle Kennedy.
Okay.
You need to get in chairs and off of this one.
Okay.
It's the leather.
Is that what it is? Like I'm just a down slope. I just keep on.
If you take a seat here, please. If you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. There's a little square microphone up there that's silver. If you can put that somewhere on your lapel, it's for the court reporter.
Just like that?
Yes. All right, if you'll keep your voice up so everyone can hear, and if you'll state your name for the record.
My name is Kyle Kennedy.
All right, you may proceed.
Officer Kennedy, on September 24th, 2022, how were you employed?
I was working for the Love Oak Police Department,
What was your job there?
patrol officer.
When people, at any point during your job, did you ever take witness statements and do interviews?
Just take witness statements mainly. Interviews are for the detectives.
And is there some training that goes along with taking those
Just
interviews?
generic, training from the academy and then whatever's on the FTO manual.
Do they have forms that you use or
Yes, sir.
have you had a chance to review your police report and review your video from that day?
Yes, sir.
And according to your report, you actually met face to face with Zanani, correct?
Yes, sir.
And you actually handed her witness forms, correct?
Yes, sir.
And are these forms, is there extra spaces on there for other people to write on these forms, or are they just for the witness?
I believe there's extra spaces, but I'm not too sure in my knowledge.
Can I approach you?
Yes.
This is just for one person.
But just in general, talking about the form itself, what are the first two paragraphs generally about?
I guess what would happen or their name and stuff like that.
Okay, you said what would happen? What would happen if they what?
If there was a, I guess, offense occurred or they want to report something to the police.
Now, when we're looking at this form at the very top, there's a spot for the witness to write their statement, right? How would you describe what's at the top?
Says before me, assigned authority, County of Bear. Basically, that's what where I would put my name and my badge number, saying that I'm the one who took the initial witness statement.
So you, if you were to do this, you would put
Correct.
your name there, right?
Yes, sir.
The witness would not put their name there, right?
Correct. It would be the officer, as it is signed, said right here.
Right, exactly. And at the bottom of the page, there's some extra spaces there. What are those for?
As you're referring to this, it's for the signature of the witness and then who obviously saw her sign his or her name.
Is that supposed to be the same person that did this paragraph at the top?
No. Oh, as far as this, yes.
So it's
Whoever-
normally an officer, correct?
Correct. Yes.
You ever heard of anybody by the name of Paige Beatty?
Not to my knowledge.
How big is y'all's police department?
I
Or was it at the time?
think 30 officers, not too sure.
Do you know 30 people? You should know them pretty well, correct?
Yeah, roughly. I was
Oh.
still kind of new, so
But if you were working with the Paige Beatty, you would probably know who that is.
yes, sir.
Now, when you handed her these forms we just spoke about, when you handed her these forms that we just spoke about, do you remember if they were blank or if anything had been filled out?
Shouldn't be. If I was, according to the video that I watched and everything, they should just be blank because they're pre-printed forms that, you give to somebody to fill out. Because it couldn't, obviously all of this stuff would have changed. Doesn't happen always on the same day or the same time and stuff like that.
But you, from your memory, you never filled out anything, correct?
No, sir.
In fact, you handed them blank forms, correct?
Correct.
And you let them leave the station with them?
Correct.
Is that normal for you to do or?
It's happened before, yes, sir. Some people want to fill out the forms at a later time.
And now you noted in your report that you didn't notice any visible injuries around her neck, correct?
According to the supplement, yes, sir.
Did you take a statement from her that day?
I believe I just handed those forms out and that was it. She was, I guess, according to my supplement, she was asking for an on-duty detective, which I was not. I was just a regular police officer. And she wanted to report something, so that's when I handed her the witness
So
statement.
she didn't trust you to take her statement. She wanted someone higher up.
She just asked for a detective.
Sustained. When an objection is made, just stop speaking, and once I rule on the objection, then you can answer. If you don't know if you are allowed to answer or not, just turn to me and I'll let you know.
Yes, ma'am.
All right, you may continue.
When you were meeting with them, did you turn your body cam on?
Yes, sir.
And after reviewing that video and refreshing your memory, did your body cam ever turn off? And if so, when?
At some point in the video, it did turn off. As far as when, I don't know when. I guess as I was handing her the statement.
And it looked like she was about to give you a verbal statement and then it turned off, correct?
Yes.
Did you turn your body cam off that day?
No.
Are you aware of anybody at your station editing or messing with your video in any way?
No.
But it does appear to cut off, correct?
Yes.
Have you been honest with us today?
Yes.
Have any of your answers here today been shaped by the fact that you just
Your Honor,
Okay.
I'm gonna see.
If y'all approach. Oh, yes, actually, could you send it? Oh, yes. Oh, you know what? Megan is by Zoom, so.
Oh, perfect. Well, that works.
All right, thank you. That's the horses, right? All right, thank you. All right, Attorney Galloway, we're ready. Cindy, are you ready? Yes. All right, the court is going to call 2025 CR 007810 State versus Catherine Marie Flores. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Megan Enriquez present for John Coons for Catherine Flores.
All right, are you Catherine Flores?
Yes, ma'am.
Do you have any objection to this attorney standing in?
No, ma'am.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And counsel, do you have any objections to the state appearing by Zoom?
No objection.
Ms. Flores, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we move to waive the peace officer enhancement and proceed on the misdemeanor offense.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault? Misdemeanor, the range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. If you go with the state, the court does not follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No contest.
No. Do you understand you have a right to jury trial?
Oh, yes, ma'am.
Do you understand you have a right to remain silent?
Yes, ma'am.
Do you understand you or your attorney can cross-examine any witnesses the state would call?
Yes, ma'am.
By entering into this plea bargaining agreement, you are not going to be doing that. Do you understand?
Yes.
And did you intend to enter into this plea bargaining agreement and give up those rights I just mentioned?
Yes, ma'am.
Right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a US citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. They're asking that your punishment be assessed at 1 year in the Bear County Jail. There's a $1,000 fine. There's no application for deferred adjudication. The state is recommending community supervision. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor, I wanted to mention one thing. When we were filling out the paperwork, I noticed that there was not a spot to check off I am a United States citizen like there normally is, but we did go over it.
Yes, they don't do that anymore.
Oh, okay.
Yes.
Things have changed in 3
No.
months.
Oh, it has.
Okay, I did advise her and she understood. Interesting.
So, all right. Did you understand that to be the plea?
Yes, ma'am.
Did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, hostility management course, and a mental health evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence.
State offer states one in attachments.
No objection.
All right, and state, have you had a chance to speak with the defendant?
Yes, Judge.
All right, state, you may be excused. Thank you.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're very grateful to Ms. Galloway and the state for taking a look at the evidence. She does have a young child. She's no longer with the child's father, so she works to support him. So if there's any way or that the court has any ideas for her to satisfy her community service hours or ways that she could buy out of it or satisfy it in another way, we would be grateful.
Are you employed?
Yes, ma'am.
What do you do?
I work at a hotel here downtown, doing front desk.
Okay. And have you ever had any prior mental health issues or diagnosis?
No.
All right, so what was happening this night?
I just felt like overwhelmed with my relationship. I don't want to get too into it, but it was kind of like mentally abusive, verbally abusive. I just felt kind of like fed up at the moment. That day I was supposed to go into work, I called in because we were arguing. And I was supposed to leave, and whenever I was leaving, the officer got there. And right away, I guess they saw me as like the aggressor because I was just, crying out of it. And, they just detained me. And from there, with the officer, she put me in handcuffs. When she put me in handcuffs, I let her know that she was hurting me a certain way. I communicated that to her, and her response was just kind of like, shut up. And she yelled in my face, and that was just my reaction. And it's not the way to react to things, but I just felt mentally drained.
Sometimes you did get, sometimes when you're having one of those days and everything hits you at once, and then sometimes this is the last thing and the last straw. But
I do want to apologize to the officer, by the way. Wasn't my intention at all.
But you'll have to do better and make better decisions and remain calm. All right. So the court is going to sentence you, as previously stated, 1 year in the Bexar County Jail, suspended and probated for 2 years, $1,000 fine, that will be probated. Proof of employment within 45 days, no employment as a home health care provider or with minors, 200 hours of community service restitution. 50 of those hours will be deemed satisfied. I'm going to order parenting classes. Once you complete the parenting classes, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied once you complete the hostility management course. And the remaining 100 hours, you can either do the 100 hours or you can write that officer a letter of apology. There should be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 2 months. Probation, is there anything else? Okay. Is there anything else you need from the court in order to be successful? Right, because did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand? Right, because this plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing, in this court, to be successful, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back here. If I'm still here, I will address it. If there are any type of mental health issues or the walls are closing in for you, let your probation officer know. I don't have them file a motion to revoke because someone is reaching out for help. And whatever you do, do not disappear. All right?
Okay.
All right, do you have any questions about anything?
No,
All right, probation is gonna go over your conditions with you and then you'll be excused. Good luck.
thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. All right. Do you have the document? All right, let's bring the jurors in. Yeah. All right, let's do some kind of, that's, you know, see, if, oh, you know what?
Yours ready to.
Oh, yes, please. All right, the witness, if you'll take the stand, please.
Your Honor, maybe you first before we begin,
Yes.
just to clarify.
Yes.
So the question is just gonna be regarding whether or not he took the plea.
Oh, they can ask him about the nature of the plea, whatever the plea bargaining agreement is, they can ask him
Is that
about the
referring
actual plea.
into the nature of the offense or?
No,
No,
just what the plea bargaining agreement is.
Cause I am gonna ask him what he pled to.
No, yes,
Okay.
I mean, what,
let me see, do y'all have the bargain?
just the top part is what we're looking at.
Right.
All rise for the jury.
The one on the bench, can you turn it towards him?
This one right here?
Yeah, make sure it's on. Thank you.
All right, everyone, please be seated. All right, defense, it's still your witness.
Mr. Kennedy, on December 1st, did you take a guilty?
Yes, sir.
You pled guilty to count one, correct?
Yes, sir.
What was count one?
aggravated assault, deadly weapon by a public servant.
And as part of your guilty plea, you've agreed to surrender your license, correct?
Yes, sir.
And also have no possession of firearm.
Yes, sir.
So if you surrender your license, that means you can no longer be a police officer, correct?
Correct.
In taking that plea last week, did you receive any benefit from the state for your testimony here today?
No, sir.
Pass the witness.
All right, state.
Yes, Your Honor. Officer Kennedy, regarding the plea agreement and any of that, was that while you were alive or after the fact?
It was after I was in live oak.
Going to your time as a police officer at Live Oak, what was your position with the department?
I was just a regular police officer.
And you said that you didn't normally take statements, is that correct?
We just handle the initial calls, and then after we're done, we hand it up to the detectives, and they're the ones that go and investigate.
And from your recollection reviewing the video, you didn't take a statement that day?
I handed out a statement, and yeah, that's what the video shows.
And is it common for complainants to take the statement and fill it out at home, not
There-
the same day?
It's not common, but it does happen sometimes. Some people don't wanna fill it out at a police department.
And your involvement with the case was just that handing the statement over
Yes, sir.
with the case?
Yes, sir.
No further questions, John.
Defense.
Just to clarify, we don't really know whether or not she gave you a statement because you turned your camera off.
I did not turn my camera off.
That's-
No further questions, Judge.
All right, is this witness excused or subject to recall?
Not from the state.
not for-
All right, the rule has been invoked. You're not allowed to discuss your testimony or view anything regarding this trial until this trial is concluded. Do you understand?
Yes, ma'am.
All right, thank you. If you remove the square, please. All right, defense, call your next witness.
I'd like to speak to Ms. Caballero.
All right.
Ms. Caballero.
Thank you.
Hello. Hi, I'll just bring you in again. Could you raise your right hand? Do you solemnly swear or affirm that testimony you give will be the truth and nothing but the truth to help you God? All right, you can lower your hand, have a seat, if you'll make sure that that square microphone is somewhere. And it's so that the court reporter can hear. All right, and state your name for the record.
Jamie Caballero.
All right. You may proceed.
Morning, Ms. Caballero.
Good morning.
Afternoon, I guess. You had testified last week. I was kind of, I guess, last week, I was kind of getting into whether or not you had a body cam, all these things. And you had told me, no, I only spoke to her on the phone, correct?
Correct.
You never met with her in person, correct?
That is correct.
And you never swore her in on any statements, correct?
No, correct.
I want to show you what's been marked as defendant's exhibit number 1. Tell the jury what this is.
That is our witness statement.
Okay, and what is this up here at the top? These first couple paragraphs, what is that?
That is just stating what officer personally appeared to the person receiving the statement, but a lot of us have them pre-filled out.
Interesting. So you don't know whether or not this was pre-filled out or not, though.
I do not.
Can you tell me who it says met in person and did all this, witnessed all this? Who does it say?
That has my name on it.
And you didn't write your name there, did you?
That does look like my signature. It may have been
pre-filled out, like I said. It's not signature, it's my print.
And you're not telling us it may have been pre-filled out to bolster your case or anything, right? You would tell the truth.
Argument.
Sustained.
Let me ask you this, if another officer told us, I handed her the form and the form was blank. How do you explain your name being there?
I don't know.
Yeah, you said it looks like your signature.
That is my print, yes.
You know, part of this statement, if it is your name, says that you were personally there in person. So if that's your signature, did you lie?
Well, that's not my signature who witnessed it, so
Interesting.
I didn't accept this statement.
Okay, so someone else wrote that and signatured it. Whose name is that? Who's Paige Beatty?
She is our clerk in the front of the police
When
department.
did you discover who Paige Beatty was?
Me?
Yes.
Oh, when I started working there,
When did you first notice that that's who signed this?
just right now.
So Paige Beatty, according to this document, says that you were there in person and that you personally swore her in, but Paige Beatty's lying, right?
Objection, Your Honor, argument that has been counsel testifying.
Sustained.
Paige Beatty signed, right?
Yes,
This statement saying you personally were there, correct?
yes,
And you were not personally there, correct?
correct.
Your Honor, at this time, I would move to enter Defense Exhibit 1 as impeachment evidence.
Your Honor, we're gonna object to hearsay.
Sustained.
I'd like to show you another statement here. It's marked as Defendant's Exhibit number 2. You tell the jury what this is.
It's the same witness statement that we provide someone that wants to file a criminal charge.
Now, you had mentioned earlier, sometimes you pre-fill out these things. Was this one pre-filled out with your name?
No,
At the bottom on Barbara's statement, when it says witnessed by, is there anybody's signature there?
no,
In your report, you had mentioned that Denani had told you which hand she was strangled with. What hand did she tell you?
Objection to hearsay, Your Honor.
Sustained.
Did Denani indicate which hand this happened with?
yes, I believe I wrote it, and
What hand was that?
Objection calls for hearsay, Judge.
Sustained.
Was it one or two hands?
one,
At any point did she ever tell you to?
no,
That's the witness.
Good
State.
afternoon, Officer Caballero.
good afternoon.
How are you doing today?
Good.
I'm gonna ask you some questions. If at any point in time my question is confusing or you don't understand it, please feel free to stop me. Or I don't understand your question, please rephrase it, okay? What was your involvement with this case?
The only involvement I had was taking the initial report over the telephone.
So you didn't take the witness's statement?
No.
You didn't watch them write it down?
No,
Your job was to gather information, kick it up to a detective,
correct,
and that's what you did in this case?
yes,
No further questions, Your Honor.
No further questions, John.
All right, is this witness excused?
Yes, sir.
All right, the rule has been invoked. You're not allowed to discuss your testimony or view anything about this trial until this trial has concluded. All right, thank you. You may step down. Defense, call your next witness.
This would now call Detective Jimenez.
All right, I'm going to swear you in again.
Yes, sir.
If you could raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, if you can lower your hand, just remember to keep your voice up if you'll state your name again for the record.
Rudy Jimenez.
All right, defense, you may proceed.
Morning, detective.
Morning.
Good afternoon, I guess. What's your current rank?
I'm sorry,
What's your current rank?
Sergeant?
Sergeant?
Yes.
And a detective is a sergeant?
No, sir. At that time, I was a corporal detective.
So
We have
you get
corporals
like-
and we have sergeants.
You get a special badge, a TV show I'm watching, they get gold or silver badge.
The sergeants and corporals are both the same. They're just a detective or corporal detective or sergeant detective.
As far as your rank, would you say you have a greater responsibility than the other officers on this case?
Yes.
What is your responsibility?
Are we talking in reference to my current position or at the time
In
this was taken?
case, what was your responsibility?
To conduct the investigation, to review all of the data that was supplied to me for the investigation.
And you previously stated in your testimony that you didn't really read through everything, correct?
I don't believe I said that.
Do you remember when you called Barbara on the phone?
Yes, sir.
And now, it had been a while, the statement's out there, it's not being turned in, and you're trying to track it down, correct?
Yes, sir.
And when you finally do track it down, you have some questions about it, right?
Yes, sir.
What were you questioning? Well, let me back up. In Barbara's statement, does she say whether it was one-handed or two-handed?
I believe I was trying to get clarification on that. And then after speaking to her, it was verified that she stated it was one hand.
Okay, one hand, not two, right?
Yes, sir.
And now when you start asking her, because on her statement, there's some stuff with arrows going up and correcting it, correct?
I believe so. I don't remember. I've seen this. It's been a while since I've seen the statement, but yes, sir.
Do you remember when you were asking her about that, she started to answer, do you remember telling her, I would hate for you to perjure yourself to support Zanani's story? Do you remember telling her that?
I didn't use that verbiage, no, sir.
What did you say?
I stated I would hate for her to say something that could potentially get her in trouble. And that I was trying to get clarification because her statement was kind of all over the place. So that's what I was trying to get clarification on.
And now when you said it could get her in trouble, you meant get her in trouble for being dishonest, correct?
Yes, sir.
Because you told her, I would hate for you to try to do something to support her story, right, and get in trouble.
I don't recall saying that, but take your word for it.
Now, you said that because what she was saying sounded like a clear lie to you, didn't it?
Objection, Your Honor, argumentative.
Sustained.
Do you remember if Barbara told you where Zanani was sitting?
Inside the vehicle?
Yes.
Yes, sir.
Where did she tell you Zanani was sitting?
Behind the passenger?
So not in the middle seat.
No, sir.
At any point in time, did she ever tell you I was sitting in the middle seat?
No, sir. This is the first time hearing that.
Objection, Your Honor, sidebar.
Sustained.
So just so I'm clear. Barbara told you it's one hand, correct?
Yes, sir.
Barbara told you she's sitting behind the passenger seat, correct?
Yes, sir.
Do you remember when you called Zanani?
Yes, sir.
What did Zanani tell you about where she was sitting?
Behind the passenger?
At any point in her statement, did she ever say I was sitting in the middle?
No, sir.
What did Zanani tell you about which hand she was strangled?
So initially she stated that she was strangled with the left hand. And at that point, I asked her to clarify a little bit more because there was a little bit of an inconsistency, whether it was one hand or two hands. So I tried to get clarification from her, verified with her again, asked her, can you reiterate exactly what occurred? She said that he reached around with his right hand, turned his body around, and then grabbed her with he grabbed her with the left hand first, turned his body around, grabbed her with the right hand. And then I asked her, are you sure that both hands were around your neck? And she stated that yes, that they were.
So there were some inconsistencies between what Barbara told you and what Zanani told you, correct?
Yes, sir. There were some differences.
Number of hands, right?
Yes, sir.
Which hand, right?
Yes, sir.
You just kept going, right? Kept going
In reference to what?
with this case.
Yes, sir. The probable cause was met to file the case.
So originally she told you he's driving with the car, reaches with his left, right?
Yes, sir, she said left hand first.
And when you asked her, are you sure, she doubled down on it, didn't she?
I believe so, yes, sir. I mean, I asked for
Well, You
clarification.
talked her out of it.
Objection, Your Honor. Argumentative misstatement of character.
Sustained.
Now, when she says he reached back with his left hand, that would have been physically impossible, correct?
Objection, speculation, Your Honor.
Sustained.
In your mind, in that moment, using your detective skills, did you think that statement's unlikely to be true?
No, sir.
Did you have any follow-up questions about that?
About reaching with the left hand,
Yes.
I just asked her to clarify whether it was one hand or two hands after she provided her statement and she stated that it was two hands, so.
Do you remember asking her, did he go straight for your throat? Do you remember asking her that question?
No, sir, I don't, but I'll take your word for it.
She told you that he went straight for her throat, correct?
I don't recall, but if it's in the report,
Would be helpful to review your report.
yes, sir.
We'll show you what's been marked as State's Exhibit number 2.
I don't see where it states it. She stated he went straight for her throat. If you could point that out.
Nani is explaining this to you. Does she tell you you pointed on her face and then choked her, or how did she describe it to you?
I believe the way I explained it was that he had turned around with the left hand and then grabbed her by the throat with both hands.
She never once mentions this pointing in the face, correct?
No, sir.
The only person that actually told you it was a point in the face was Miosha, correct?
Yes, sir.
Why then didn't you follow up with Zanani and say, was it a point to the face or not?
That was the follow-up. That's where I got the clarification. This was after speaking to Barbara, Miosha, and Mr. Duran. This was the follow-up and final follow-up to get the clarification.
So when you got this clarification about the point to the face, she told you it was straight to the throat, right?
I don't recall that being said.
So you got clarification, but you don't remember what was clarified?
I got clarification in reference to whether or not it was one hand or two hands.
Now, when you're asking Zanani this, you've told her, hey, look, this is what everybody else has said, right? Before she answers?
I don't recall, but I'll take your word for it.
Why would that be a bad thing to do if you're investigating someone's honesty, to tell them what everybody else said before you ask?
I don't think it is a bad thing. I mean, it's perception during the investigation, but the most important thing is to try to get clarification on what occurred. So it's reference to telling somebody what another person stated that was there with them at the time of the assault. I don't believe that that was a bad thing.
So in your professional opinion, your detective opinion, it's okay to give them an opportunity to change the story.
Objection, Your Honor. Argumentative.
That'll be overruled.
No, sir, I don't recall giving her the opportunity to change her story.
You told her what everybody else said and she changed her story, didn't she?
I don't recall the story being changed.
If you said left hand, or if she said left hand, and you press her on it, you start talking to her, all of a sudden it changes, doesn't it?
No, sir, the report states exactly what she stated, that she was choked with two hands.
But you just said you don't remember what she specifically told you on the phone call, I thought.
I've never said that, sir.
But her first statement was that it was with one hand, correct?
Yes, sir.
And her first statement to Officer Cabrera was it was with the right, right?
I believe so, yes, sir.
And then she changed it to left when she talked to you.
Yes, sir.
And then in that same phone call, she changes it back to right, correct?
No, sir, that phone call was where it went to two hands.
Okay, that's
So
what.
that's
so
where,
First it's right hand, then it's left hand, then in the middle of your conversation, it switched to two, right?
it wasn't during the middle of the conversation. I could tell you,
During the conversation.
that's why I called to get the clarification because of the inconsistencies with it. So,
And the two hands doesn't match Barbara's statements, correct?
no, sir.
Just to make sure, you said you would call Zanani to clarify all the inconsistencies, correct?
Yes, sir. In reference to the choking.
It's pretty important to focus on the inconsistencies, right? When you're trying to get to the truth.
Yes, sir, and that's what I did.
And you had stated during Duran's, when we were talking about Duran, you said, well, when I pressed him, his story kind of changed a little bit, correct? And I thought that was suspicious.
I don't recall saying that.
Do you think it's suspicious that her story has changed so many times?
It's documented in the report.
Okay. No. Okay, I passed the witness.
State,
Yes, Your Honor. Good afternoon, Sergeant Jimenez.
Good afternoon.
How are you doing today, sir?
Doing well, how are you?
Doing well. I'm gonna ask you a couple questions. If at any point in time, sir, you don't understand how I'm asking the question or it's confusing, please feel free to correct me or say, oh, I don't understand. Okay?
Yes, sir.
Thank you, sir. Your current position is a sergeant, right?
Yes, sir.
But that's not what you were back then.
No, sir.
You were a corporal detective
Yes, sir.
and your job was to investigate cases.
Yes, sir.
What did you do when you investigated a case?
I reviewed all the data, everything that was turned in from patrol, anybody else that had any type of association with that specific case that I was assigned.
Is that what you did here?
Yes, sir.
So when you talk, who did you talk to in this case?
I spoke to complainant, Mr. Duran, spoke to the witnesses, the grandmother, and I believe the mother, that were all inside the vehicle.
And you talked to each of these people different times in this investigation,
Yes, sir.
and you try to clarify what you thought were inconsistencies.
Yes, sir.
At any point during this entire investigation, did Zanani ever deny being choked?
No, sir.
Did she ever deny being strangled by her stepfather?
No, sir.
Did she say this didn't happen? I don't want to move forward with it.
No, sir.
Did Barbara say it never happened?
No, sir.
Who were the people who said it didn't happen?
Mr. Duran and Miss Miosha.
Yes, sir. And after conducting your entire investigation, you still felt necessary to file the case with the district attorney's office?
Yes, sir.
And that's why we're here today.
Yes, sir.
No further questions.
Briefly. During the course of your investigation, did you run across some pretty hateful text messages addressed to Mr. Duran?
Hateful would be an opinionated, but I did run across a text message. Yes, sir.
Profanity laced.
Yes, sir.
And those were sent from a burner phone, correct?
I don't know. I don't know where I was sent from.
They weren't sent from Zanani's phone, were they?
I don't know.
Do you remember following up with Zanani and asking her if she wrote these messages?
Yes, sir.
What did she tell you?
She stated that she did.
And did you ask her, why is it coming from a different phone number?
No, sir. Once she clarified that she did send it, I didn't feel the need to determine why it would come from a different phone number, whether she got a new cell phone. Had no part of the investigation.
When you're doing investigations, right, and you're getting text messages, does your detective radar go up when they start sending it from burner phones or numbers that aren't their own, that no one knows?
If it's related to the case, absolutely, but a burner phone or a different phone number has no association with an assault. So that part isn't relevant to my investigation.
Who is she sending these super hateful messages?
I believe Mr. Duran.
Was there any response from Mr. Duran? Mr. Evans, I'm sorry.
I can't recall.
I need to mark this, I'm not sure which. Fourth,
Yeah, Judge,
I'm sorry?
to defend, yeah.
I'm gonna show you what's been marked as defense exhibit number 4. Can you tell us what that?
Yes, these are the, excuse me. The text messages that Mr. Duran provided me.
And in looking at this document, do you see if there's any, maybe a motive for Zanani to lie to you that might perk your interest in there?
Objection, Your Honor, argument it.
Sustained.
When you're reading through these messages, do you, in your professional opinion, see anything that might show a motive for Zanani to lie about Mr. Evans?
Objection, Your Honor, proper opinion.
Sustained.
Was there anything in these documents that caused you to take further investigative steps based off of what you perceive to be a motive?
Yes, sir.
And what was that?
The part where she said you choked me.
I spoke about the motive, her motive to lie. Was there anything in here that made you take further investigative steps as it relates to what could be or may be a motive to lie in here?
Objection, Your Honor, speculation.
Sustained.
Were there any responses from Mr. Evans?
No, sir, I don't see.
And going to this last page, where did these messages that you're seeing come from?
From Mr. Duran.
And did Mr. Evans ever tell you, I think it's around who they came from? Did he indicate that he wasn't real sure who they came from?
He said he believed it was from the complaint.
But he said, I don't know, I believe.
He mentioned that it was from a different number that did not appear to be hers. And then stated that he did believe that it was from her.
But she's admitted already these are her, correct?
Yes, sir.
And now these messages, they're coming in one after another.
I would assume so, yes, sir.
She's kind of blasting him with messages and he's not saying anything back, correct?
I don't know the times in between when the messages were sent. This was just what Mr. Duran provided to me. I don't know the times or anything like that, whether they were consecutive or if there was a time lapse in between the messages.
Why didn't you try to get these messages?
Mr. Duran had provided them to me. And she stated that she had sent them.
She sent about 5 messages. All of them were filled with profanity and cursing.
I don't know how many of these pages were from one message or things like that, but yes, sir, there's profanity in this.
And you as a detective weren't at all interested in seeing the rest of the conversation?
It had no, I mean, other than the portion where it says he choked her. Again, I wasn't investigating any type of harassment or anything like that.
And so you don't think there's anything else she said in here that would be relevant? Maybe relevant to her, honestly, nothing in here that you could see.
Yeah, there's several things in there in reference to him choking her.
I'm not
admitting-
talking, I know you wanna talk about, you can speak with that. I'm asking you, if there's anything else in here, right? That she says that makes you maybe doubt her story.
Objection, Your Honor, ask an answer at this point.
Sustained.
I pass the witness.
State?
In regards to the text messages. Do you know who they're from?
Yes,
How do you know that?
the complainant told me that she sent them.
Zanani admitted to you that she sent it, these
Yes,
text messages?
yes, sir.
Did at any point in time she try to hide them?
No, sir.
You got a copy of them from Mr. Duran?
Yes, sir.
You reviewed them?
Yes, sir.
And they're filled with profanity and curse words?
Yes, sir.
That's not a crime, is it?
No, sir.
Is choking someone a crime?
Yes, sir.
And that's what you were investigating?
Yes, sir.
May I approach her?
Yes.
I'm showing you what's been marked as offense exhibit number 4. I know we just went over it ad nauseum. How do you recognize that?
I don't understand the question.
How do you recognize those are text messages?
Just the way that it's worded. I mean, plus, Mr. Duran told me that he received them as text messages, and then the complainant told me that she sent them as text messages. So when I received them, that was the interpretation. These were text messages.
And you reviewed those as part of your investigation?
Yes.
And those messages there, have you had a chance to review
When I initially got them, yes, but it's been a while.
them?
up
Do they
until
look
today.
altered or modified in any way?
No, sir.
Your Honor, at this time, the state would move to admit defense exhibit 4 into evidence.
No objection.
All right, defense exhibit number 4 is admitted without objection.
And how did these text messages affect your investigation, if at all?
There's several things in there where there's, again, the statements about being choked and that Zanani or the complainant referenced to Mr. Duran that he knew that he had done it and that he could not admit to it.
And you were asked on direct examination earlier if she ever denied sending this.
No, sir.
Zanani never denied sending these messages?
No, sir.
She never denied anything wrong that she did?
No, sir.
Was there a person in this case who did deny anything wrong that they did?
Yes, sir.
And who was that?
Mr. Duran.
No further questions, Your Honor.
Any further questions?
Yes. Briefly. Now, Denani never told you that she sent these messages, right? You had to confront her first with them before she admitted that she sent.
I asked her about them once I received them.
But
Yes.
she never told you I sent these messages, correct?
No, sir.
And then you testified earlier that you didn't see that there was any motive to lie in here, correct?
No, sir.
So when you saw her say things like, "You're a vile, disgusting human being," that didn't do anything for you?
That's common typically from a potential victim that they would contact the person that may have violated them or whoever they feel violated to reach out and react in that manner. So there was nothing uncommon about
Is it
that.
normal for people to say, "You're a passive aggressive, weak, dumb bitch"? "You're a fucking bitch, not even a man"? "There's no balls or dick between your legs"? That's normal stuff?
Depends. Everybody reacts differently when they're
Does
choked.
that sound like she hates him, or what does that sound like to you?
I don't know. I don't know how she reacts.
So. She's sending these out, right? Trying to get a response from him, correct?
Objection, Your Honor.
Okay.
Speculation.
Sustained.
Do you happen to know if she created these during the same time she was trying to go to the police?
I have no idea.
Did you ever take any steps to figure out whether or not she's sending these to bolster her case?
Objection, Your Honor. Improper argument. And 4-3 and argumentative.
That'll be overruled.
No, because Mr. Duran's the one that provided those to me, not her.
Why would that matter?
Because you just asked if she was creating those and sending them to bolster her case. If that was the case, she would have provided them to me when she did it, Mr. Duran did. So that's not meeting your argument.
You ever think maybe she wouldn't want you to see these because they're so nasty?
That just contradicted what you just asked. So I don't know what you're trying to get from the line of questioning.
So just to recap. There's some inconsistent statements coming in from Zanani and Barbara, correct?
Yes, which would clarify.
Zanani changed her story from one-handed to two-handed.
The statements
Objection,
were,
that's an answer, Your Honor.
Sustained.
She changed her story.
Objection, Your Honor, this line of questioning is unduly cumulative and it's all asked and answered.
All right, let me hear the question, please.
Just trying to think.
Yeah, it should be just one. Complete, and she sent the entire.
Just that you weren't there, correct?
no, sir.
Six.
So you never saw any of this stuff, correct?
No, sir. I typically don't when I'm doing my investigations.
You're like the rest of us, you're seeing this stuff as they're talking about, it, right? As they're giving you statements, that's when you're seeing it.
As they're reporting it, yes, sir.
You never interviewed them in person, correct?
I already answered that.
Yeah.
I already answered that question, Your Honor. They asked me last time and
No, I understand. So the way it works is, either side can ask whatever questions they want to ask. And then if there's an objection, then I'll respond to the objection. So,
what was the question again?
You never spoke with Zanani face to face, correct?
Objection, Your Honor, asked and answered.
sustained.
Reviewing everything that you've done with this case and everything that's happened, are you willing to admit there's some things you probably should have done differently?
No, sir, because the probable cause was met, which is why it was filed.
So you are, looking at this jury, you're proud of this investigation.
Yes, sir. It's easy to go back and Monday morning quarterback a case when you've had it for 3 years. You can find loopholes, you can find holes in every investigation. At the time that my investigation was complete and turned in, the elements and the probable cause were met. So I'm 100% happy with what was submitted at the time.
You're proud of the work that Charles Police Department does.
I don't work for them anymore, so.
Is that because they're under? What do you know about the investigation?
Objection, Your Honor, for improper argument. May
All
we-
right, the parties approach. All right, any further questions?
Just two, Your Honor.
All right, you may proceed.
When confronted or when you asked the nanny, she denied she sent these.
No, sir.
Who gave them to you?
Mr. Duran.
No further questions, Your Honor.
All right, is this witness excused or subject for recall?
Not from the state judge.
It's good to go, Your Honor. Thank you so much.
Thank you.
All right, so the room has been invoked. You're not allowed to discuss your testimony or do anything in regards to this trial until the trial is completed.
Yes, ma'am.
All right, thank you.
Thank you,
Please leave
Judge.
those
Appreciate
questions.
it. Thank you.
Sure.
I'm glad you reminded me. I forgot.
Defense, call your next witness.
Your Honor, at this time we rest.
State,
We rest as well, Judge.
and do both parties close?
And we close.
Close, Your Honor.
And we close, Your Honor.
All right, ladies and gentlemen, I'm gonna have you go back to the jury room. There are a couple of things we need to take care of. And then I'll read to you what's called the jury charge. And then both parties will have an opportunity if they choose to give their closing arguments to you. Everyone, please rise for the jurors.
Thank you.
All right, and if you all will make sure that you keep your mics on for Cindy.
This one, I don't know if
Yes.
it's been off or on, I don't know.
All right, you ready? Are both parties ready?
We are good.
All right, let's bring them in.
All right, for hearing.
Right, everyone, please be seated. All right, ladies and gentlemen, you've heard all the evidence you're going to hear at this time. I'm going to read to you what's called the charge of the court. It's instructions. You don't have to memorize the instructions because you will have the original with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Duran Evans, starts charged by indictment with the offense of felony assault alleged to have been committed on or about the 24th day of September 2022 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1. Our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits a felony assault if the person intentionally, knowingly, or recklessly causes bodily injury to a person whose relationship to or association with the defendant is described by Section 71.003 of the Texas Family Code, if the offense is committed by intentionally, knowingly, or recklessly impeding the normal breathing or circulation of the blood of the person by applying pressure to the person's throat or neck. 2. Section 71.003 of the Texas Family Code defines the term family as including individuals related by consanguinity or affinity as determined under sections 573.022 and 573.024 of the Government Code. Under section 573.024 of the Government Code, two individuals are related to each other by affinity if the spouse of one of the individuals is related by consanguinity to the other individual. Under section 573.022 of the Government Code, two individuals are related to each other by sanguinity if one is a descendant of the other. 3. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Spouse means a person who is legally married to another. 4. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards of substantial and unjustifiable risks that the result will occur. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 5. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 24th day of September 2022 in Bexar County, Texas, the defendant, Duran Evans, did intentionally, knowingly, or recklessly cause bodily injury to Zanai Jefferson, a member of Duran Evans's family, by intentionally, knowingly, or recklessly impeding the normal breathing or circulation of the blood of Zanai Jefferson by applying pressure to the throat or neck of Zanai Jefferson, then you will find the defendant, Duran Evans, guilty of the offense of felony assault as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Duran Evans, not guilty. 6. You are instructed that if there is any testimony before you in this case regarding the defendant having committed an offense other than the alleged offense against him and the indictment in this case, you cannot consider said testimony for any purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty and must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and verdict forms are attached. Each side will have 15 minutes to give closing arguments to you. State, are you prepared to proceed?
We are, Your Honor. Ladies and gentlemen of the jury, opposing counsel, hey, please the court. Good afternoon, guys. I know it's been a long and tough journey to get here. We've been here all last week and now here today. Before I begin with closing argument, I do have a couple housekeeping matters to attend to. You heard Judge say, like, police reports that we mentioned, witness statements that were not admitted to evidence. That kind of thing doesn't go back there with you. You know, I wish we could admit it. Unfortunately, there's rules of evidence that we have to follow. So while they did mention it a lot, we can't send it back there with you guys, okay? And then secondly, if you guys have a question regarding any of the evidence of the testimony that was up there from any of the witnesses, you guys have the opportunity and the power to ask. However, it has to be a very specific way. I'm gonna give a brief example, right? If, let's say this was a case regarding a motor vehicle accident. Some of you guys remember the witness testifying that the light was red. The other half of you remember that the witness testified the light was green. The way you ask that question is, we remember that some of us that the light was red and others that the light was green. Please read back the portion of the record where the witness testified as to the color of the light. If you ask that question incorrectly, what you're gonna get is you have all the law and evidence before you. So if you get that, you ask the question, that's what happened. Or we can't ask the question. We can't answer it for you. At the beginning of this trial during voir dire, my partner came up and explained beyond a reasonable doubt. I wish I could give you a definition, you know, we meant A, B, and C. Unfortunately, here in Texas, we don't have that. What we have is, it's not beyond all doubt. It's not beyond a shadow of a doubt. It's not 100%. The best example that I have is if we look behind here, our Judge Boyd, we have the American flag. I can tell you beyond reasonable doubt that that's the American flag. It's not missing any stars. It's not missing any stripes. We don't lose our common sense at that door. Where are we at? We use our common sense, right? We're in a courtroom in the state of Texas, here in Fort Law. That flag shouldn't be missing anything. The same thing with this case. You know, you take all the evidence you've heard, and you guys reach beyond a reasonable doubt, whatever decision you make it from the day. Now, for our case here with Mr. Duran, we're here for choking strangulation. What that means is that on or about September 24th, 2022, in Bexar County, Texas, Mr. Duran Evans intentionally, knowingly, or recklessly choked Ms. Anani Jefferson by impeding her no more breath or circulation. We're not arguing about the date. Everyone remembers going to the movies. Everyone remembers that night. It started off great. We're not arguing that it was in Bexar County. We're not arguing that the two people were present. In fact, we've heard from 4 people that they were all present, including the defendant in the statement himself. What we're arguing about is what makes this a criminal action. Ms. Anani Jefferson and her grandmother Barbara testified that there was a hand around Zanani's neck and she couldn't breathe. That's what we're here about. Now you heard from her family saying that Zanani is a liar, she's terrible, and she overreacts. Well, everything that comes out of her mouth is exaggerated, and she always is the one to cause these arguments. But you saw her on the stand. You saw her in was probably one of the most stressful positions of her life. She got up there and she admitted she sent these text messages. She admitted that yeah, she does overreact, she doesn't get heated, but she didn't do that when she was getting cross-examined. She wanted you guys to hear the truth. She wanted you guys to see who she was and tell you what happened to her. Now, at the end of this trial, my partner's going to come up here and tell you, find the only verdict for the law, the evidence, and the facts mean that's guilty. We reserve the rest of the time for rebuttal, Judge.
All right, defense?
Thank you. Thank you.
Yes.
You know, guys, I apologize if I was a little emotional in here. I get a little bit upset or angry, but it's been 3 long years. This thing's been eating a hole in my stomach. So I'm worried. At the end of the day, this is why we come to a jury. Because you get to see what all these people said. We get to get them up on the stand, right? You get to use your mind, your brain, common sense, figure out who's being honest and who's being dishonest. Keep in mind, I don't have to prove anything to you, right? Now, I do think we proved a lot of things to you, right? There's so many things going on here. I've never done this before, but I wrote down a list just because I'm nervous. I want to make sure I hit everything, right? Every defense attorney's worst nightmare is to have an innocent client that gets convicted. That's terrifying. It should scare y'all too. So let's take this seriously. Let's think about these things. First thing, was it the left hand or the right hand? Right? Left or right? Zanani doesn't know. She says it's the left pretty confidently. Then she says it's the right. First statement, she said it was her right to Officer Cabrera. You heard that. Then she talks to the detective and she changes it to the left. And when he pushes her a little bit on it, she flips back to the right. You heard also this issue about one hand or two hands, right? It was one-handed when she first came in. One-handed when she talked to Officer Kennedy, right? Then it changes to 2, right? What does Barbara say? Barbara says in her written statement that's closest to the event, it's one hand. You heard that detective followed up. Are you sure it wasn't 2? No, it's not 2, it's one hand. Then you saw Barbara get up here and she told a different story. pretty big inconsistencies, right? Something this dramatic, something this big, and you're flipping your stories around. And it's not like I don't remember. It's like I know this is what it is. Right? And then it flips. Number 3. Was it a point and choke or straight to the choke, right? Because you heard from these witnesses, oh yeah, she says it was straight to the choke, right? She never says it was a point, right? Until she gets into court and she's on the stand, right? And the reason why she's changing it is because she knows these other people know what really happened and they know it was a point, and she's trying to bolster her case and she's trying to change her story now, hoping that you guys won't pick up on it and hoping that she can outsmart you guys. Next thing, was it an aggressive U-turn and throw everybody in the car around and turn around and come back, or was it a normal U-turn that we would all make, right? That's another detail she invents when she's up there on the stand. I was gonna call it a stage, right? Stage where you tell stories. Maybe it is stage for her. No, she changes that trial. And why? Because she knows there's a problem. Durant's pretty chill. He comes in there and helps her find the phone. He's being helpful. Why would it make any sense that he would flip out and choke you with 2 hands in the car in front of everybody while he's driving in a parking lot? Well, that's why she's got to lie to you and start laying this groundwork. Well, it's whipping the car around and sprinting inside. And when she's pressed on that, she kind of rolls back on it, didn't she? She's lying to you, hoping that you will buy it, right? Nobody took the time to vet anybody, to look into this thing, right? Except for y'all, right? So are y'all going to vet it? Are you going to hear these inconsistencies and actually think about what the implications of them are? Next thing she changes. You heard Barbara say, it's the Lexus. Yosha, it's the Lexus, right? Yet when she's on the stand, first time ever on the stand, she changes it to a Hyundai, right? Which she says is a smaller car. Then take Sherlock Holmes to figure out she's changing it because she's starting to realize, hey, it's kind of impossible for him to do that. I better make the car smaller, right? Which brings me to the next thing. Even after she's shrunk the car with her lies, she knows, wait a second, it's still kind of freaking impossible. So why don't I say I'm in the middle seat, right? Why don't I just say I'm in the middle seat? Don't you think that she would have mentioned that earlier? How does it make any sense that she would say, I'm behind the passenger seat, Barbara says she's behind the passenger seat, Yosha says she's behind the passenger seat, it's called and confirmed by the detective. Over and over, she says that until she takes the stand, now she wants to be in the middle seat. And she thinks you're too stupid to figure that out. Did you figure it out? Did you figure it out? Let me ask you. She's up there. She wants to pretend, right? You're assessing her credibility. She's up there. Yes, sir. No, sir. Ooh, I wouldn't want to read a curse word. Does that sound like the testimony of the type of person she is and was? Does that look like what she says in these messages? Does she seem like a person that's too shy to do that? Or is she doing that because she's hoping that y'all are too stupid to figure out that she is an aggressive person and she's lying and manipulating you up there and calling me sir and doing all these things because she's trying to manipulate you. That's why she did it. We've been around people that do that kind of stuff. We know what that means. Then we come to this issue of whether or not Granny's getting kicked out of the house. She tells us, no, I never did that, right? Why would she lie like that? Because you can start to connect the dots as to why Barbara's not telling the truth, right? Barbara lives with her. She's her caregiver is how she describes it, right? Not much of a caregiver if you're trying to kick them out of your house because they won't back your story. And think about Barbara. Barbara didn't swear to that statement she made. She didn't forge anybody's signatures on there, right? She put it in blank because it was handed to her blank. Just like that officer told you, right? I know it was blank. I saw it in my body cam. It was blank. What does Officer Cabrera say when she gets up there? Oh, I might have filled it out beforehand.
1 minute.
Last thing, she's accusing people of stealing the phone, right? She couldn't be honest about that. Why? Because she doesn't want you to know that she already was making false accusations before she ever made this false accusation. Exactly what I told you happened in that opening is exactly what happened. There was never any choke. There was never any choke. And this has been an embarrassment of an investigation. This thing should have never made it this far. We've been through enough. It's time to put an end to this thing, right? And I can't do it without you. I've been trying. I could not do it without you. So I apologize. I haven't slept much. Picked up smoking with Deborah outside. Which, by the way, thank you, Deborah. How about that? Thank you, Deborah. Thank you, Jeff. Thank you to the trial team. You know, mentoring me a little bit, right? It's a big thing. I'm freaked out, man. I don't. What happens if this jury believes this, right? But at the end of the day, our faith's in you. So make the right decision. You know she's lying. I could have done more reasonable doubt. This thing, he's not guilty, guys. Let's end this.
Yes.
You know, the toughest thing about being a defense attorney, so I used to be a prosecutor too. But the toughest thing about being a defense attorney is defending guilty. There's somebody's life. And when you know that they're innocent, yeah, you do lose some sleep. Yeah, you are upset. Especially when you know that the person who's making the accusations is a liar. She's always wanted to be the center of attention. And guess what? This trial gave her the star show. She got to be the center of attention. But she kept lying. When she was up there, you could see the wheels in her head every time she was confronted with something. The wheels in her head were spinning. It's like, okay. And her sisters and her mother all said that when she's confronted with the lie, she doesn't back down. She doubles in. And then she starts to modify it, to change it, to fit her new narrative. Because she's still the victim. She's still the victim. Her parents and her sisters love her. But she's got some serious issues. And God help her. But those serious issues shouldn't put a man's life in jeopardy because she was throwing a tantrum. She kept changing her story. And it doesn't even make sense if you think about it. He's driving, even if he's going 5 miles an hour. Think about how the car is set up. You're driving, you got your hand, and he's going to reach over with the left hand. No, unless he's got Stretch Armstrong arms like the little toy in the 70s where you could stretch the arms really long. Okay, that ain't happening. And so when she was confronted with that, and it's, yeah, no, wait a minute. I moved my hand and it was with the right. And wait a minute, man, now it's choking with both hands. Think about it. Did you ever hear her testify that he was over the chair? Because that's the only way he's going to be able to reach her, if you believe her. This case is about reasonable doubt from day one. Would you want to convict somebody based on the level of investigation on this case? Because just because I accuse somebody of something, you would think that the cops would do some level of investigation. So let's just go with somebody's making an accusation. So, man, why don't you come into the police station? Let me talk to you. I want to be able to judge your credibility based on my years of experience dealing with these types of cases. And I want to be able to see your body language. I want to be able to see if what you're telling me sounds kind of plausible. But he had this conversation with her on the phone. All the witnesses were on the phone. But they want you to put him in prison and find him guilty for this type of an investigation. And then we get a cop who is charged with and convicted, pled guilty to a felony using a weapon, can't be a peace officer anymore. And oh, my body camera just went off. How dinky is that one? And then we have the first officer, bless her heart, Caballero, who got up there and said, you know, I just talked to her on the phone. I never met with her in person. Officer Kennedy, the cop, that's the bad cop. I gave him 2 blank statements at the same time, Miss Barbara and to Zanani. But yet, Zanani's has Caballero's name on it, and the other one doesn't. A good investigation, according to, and even Detective Jimenez admitted when I took him on cross, that a good investigation is you want to keep your witnesses separated. You don't want them to be able to collude with their stories. But that didn't happen here either, because Kennedy gave them both statements and said, here, take it home, man. Go ahead, chit chat with each other. And you heard the sister, Isis, testify under oath, and she's a sweet, credible lady. Who got up there and said, yeah, Zanani called me up just in a couple of days, could have been more than a week after this supposedly happened. And she says, hey, I want them out of my house. Huh? Who was living with her? Grandma. She wants grandma out of the house. Grandma don't got no place to go. So it's a reasonable inference, ladies and gentlemen, that grandma's been put under pressure by Zanani. We've all heard how Zanani gets when she doesn't get her way. She's confrontational, she's aggressive, she's verbally abusive. Do you think that Miss Barbara could have sustained putting up with that? Or she's gonna fold. I got no place to stay. So is that what you want me to put down on a piece of paper, baby? I'll do whatever you want. Because I just can't fight it anymore. The whole family
2
said
minutes.
that every time that she doesn't get her way and she throws a tantrum, the only way to diffuse, because you can't argue with crazy. They just get up and leave. They all love her. They've all wanted to help her. Iran has helped her repeatedly over the years. Even helped her put his name on a note where he's responsible. If she don't pay that car note, guess who's gonna be knocking, hey, come pay me the money. Who does that for somebody unless you love them? You don't sign your name on a legal contract saying that I'm gonna be in debt for a vehicle. Reasonable doubt. Use your common sense. At the very beginning, when the state did their opening argument, they used the term, he says, accountability. Accountability. Let's hold the defendant accountable. Well, I put it to you this way. Accountability, let's hold Ms. Zanani accountable. And to show that you can't manipulate the system, you can't try to ruin some man's life because you're pissed off. And this is a person who says that she's never, she was real hesitant to use some dirty words. Please read the dirty words. That right there should tell you that what she was up there was a false presentation before you. You want to know who the real person is? Right here. If she doesn't get her way, she's mean. She's vindictive. On this type of evidence, I implore you, because I trust the system and I trust each of you, to find my client not guilty, because that is in fact what he is. He's not guilty. And I'm asking you to do that for me and for Mr. Duran Evans. I thank you for your time and your consideration. And most importantly, I thank you for taking time out of your life, because I know it's not easy for you to be here today and for this past week. So I want to say thank you on behalf of my client, as well as the state and the court. I appreciate you. I won't be able to get up again to talk. The state now gets to have a rebuttal. So they're going to say everything that I just told you. I'm full of it.
Time.
Remember that. I don't get to speak again. Thank you very much, ladies and gentlemen.
All right, state, you may proceed.
Your Honor, I forgot to ask John, may I have a 2-minute break?
Yes.
Yes, it's been 3 years since this happened. Yes, he's waited 3 years, but so has the victim in this case. Okay?
Your Honor, I'll
She
object
waited
again to
3
the use of
years.
the word victim. He's been admonished and asked.
So is the complainant in this.
All right,
case.
so that objection will be sustained.
Thank you.
All right, you may continue.
Complainant in this case has waited 3 years. Get up on the witness stand and tell you what happened to her that day. Very traumatic experience for her, as she said. Scared, and she was frightened. This defendant put his hands around her neck. You've heard big word over here that they are trying to make liar, pants on fire. This is all noise over here, okay? Consider, if you will, like I mentioned during opening statement, who really has a motive to lie during this trial? Does the complainant have a motive to lie? She's not getting paid for being here today. She's not getting any benefit. Okay, now, additionally, consider if she and her grandma are going to lie to you today, why would they keep the lie to just hands are on the neck for 40-ish seconds. Why not make it a true lie, a big lie? Not only did he choke me, he punched me, gave me a black eye, he broke my jaw, he threatened to kill me, my grandmother, my mother, everybody in the car. If you're gonna make a lie, make it a good lie. Why keep it just that? Okay, consider that. Now, as my partner mentioned, yes, she was challenged. She was grilled, asked 100 and something questions up on here by defense. She never faltered. Okay, if she's such a bad person, why isn't she using all this language that you're saying right there? Okay, she never denied being choked. Her own sisters have said she's never filed any type of reports before. So all this from a bad person who likes to, lie when she gets her way, really? Because this is what happened. This happened to her. Consider, if you will, as well, the testimony. Okay, this is the evidence that you guys got to consider. Everybody that got right up here and testified. You heard from the complainant. You heard from her grandma. You heard from Myosha. And then you heard the recorded statement. You guys can take back the recorded phone call of the defendant. All right, all 4 people in the vehicle. 3 of which acknowledge the fact that there was some type of contact, some type of an assault that took place. The only person who didn't was his wife.
Mischaracterization, 3 witnesses, it was just the complaining and her grandmother.
All right, ladies and gentlemen, you will remember the evidence as it was presented. You may proceed.
Thank you, Your Honor. Only person who says that nothing like that happened is the mother in the front passenger seat. Okay. Now, reasonable doubt, yes, was explained to you. Okay. But you have to ask yourself when you're back there. 3 questions. Right? You want to have a doubt. For 1. Number 2, is it reasonable? And number 3, does it go to the elements of the crime? Let me tell you what doesn't go to the elements of the crime. Middle seat, back seat behind whoever, that's not part of the elements. A U-turn, that's not part of the elements. High stepping like they're trying to challenge their own, that's not part of the elements. On or about certain day here in Bexar County, defendant, complainant, impeded the breath. That is what you all have to consider. That is where, if you have a doubt, has to apply to one of those things. Okay? Consider also, if you will, choking someone, impeding someone's breath, that's a very personal and intimate thing. You cannot accidentally trip and have your hands fall on someone's neck, okay? That you're literally holding someone's life right there in your hands. Now, the reason why the law doesn't put into account specific time frame that you have to do is because everybody's different. The law understands that some people, short time or long time, could be a different story. Okay. You did hear in his recorded statement, he wanted to get her attention. This complainant, he has helped with a car, helped her move, did all these good things for her. How dare she disrespect you? Okay. How dare she mistreat him, his vehicle? So yes, everybody has their breaking point. He snapped, he got angry. He pointed his finger in her face and then put his hands around her neck. Okay. And when asked about that in this recorded conversation, you guys can take back and listen to again. Listen to how the conversation goes from beginning up until it comes to the point when first question asked whether or not assault took place. Notice their conversation is normal conversation. All questions are being answered right away. First time the detective asked him, did an assault take place? No. Why the need for the pause? He's caught, he's thinking, what do I say? at this particular time. Okay, listen to it again, ask that pause. Shouldn't be any need for a pause if it really didn't happen, okay? Now, as I mentioned, all of this over here is noise. Only evidence you consider are what you heard from all the witnesses up here. This recorded phone call. These texts. All that you don't need to consider. Got all the noise back here, okay? Do not get distracted by that. Now you might be thinking about how bad the language in here in these text messages are that you guys can take back and read. Yes, I'm gonna admit there's profanity in there, there's bad words. But consider, if you will, we're all human beings as well. We all get angry, especially after having something like that done to you. She's confronting the person that did this to her. She's not gonna be pleasant and mindful and say, you know, well, I appreciate you doing that to me, thank you. No, I mean, you have a right to be angry for someone who did something that bad to you, okay? Yes, I did say during the opening remarks that this is all about accountability. I'm not asking you all to say that the gentleman right there is a bad person. I'm asking you to tell him what you did was bad. You need to learn from it. You need to be held accountable for it, okay? When you get back to the jury room, one of the first things you all need to do is decide which amongst you is going to be your what's called presiding juror. You may have heard the term foreman, okay? You'll decide which one of you is going to play that role, kind of preside over and kind of control the conversations you guys are having as far as your deliberation goes. Once you do, at the end of your deliberations, you discharge of the court that the judge read from you. If you miss anything, please don't fret. You're going to take exactly what she read to you back into the jury room, read from it as many times as you need to. But ultimately, what you're going to do is you're going to go to the very last page where it says verdict form. You go down to the second one. We, the jury, find the defendant, Duran Evans, circle guilty. Presiding juror signs his name right there. This defendant is guilty. They're committing a felony. He must be held accountable for doing this. I thank you all so much for your time today.
Right. Ladies and gentlemen, the deputy will take you back to the jury room. And sit in your record. If I could have. I'm sorry. Thank you. And if I could have the defense